Have y'all had the opportunity yet to get with Ms. Merchant and confirm an approximate date for her that you plan to call Arnold?
I need to confirm with our investigator, see if he sent the message. We have the date. Let me just confirm if he emailed her.
Okay, and that's going to be more than just confirming the day. That's also going to be, y'all are going to need to get with her and hammer out whether and the scope of any kind of an immunity order.
Yes, Your Honor.
All right, okay. Let me know that in the morning if you don't mind.
Yeah, they don't want to mess with her. Boy, this plea agreement that she wrote up for Duke does not help the state at all. All it does is point the fingers back at him and nobody else, which is stupid because as the state tries to compile this BS, you're trying to prove everything is in uniformity. But don't take my word for it. Let's just go ahead and read what Ashleigh Merchant wrote a couple of days ago that absolutely scared the dog out of the Honorable Paige Whitaker, because I got something to show y'all in a previous video that a couple of y'all didn't watch. Let's go. Honorable Paige Reese Whitaker, CO, Laura Percival, Superior Court of Fulton County. State versus Williams, issues with proposed testimony of Martinez Arnold. Dear Judge Whitaker, I represent Martinez Arnold. Mr. Arnold, a former defendant in the above matter, I am submitting this letter in anticipation of Mr. Arnold's upcoming testimony. The state recently advised me that the state intended to call Mr. Arnold today, October 16, 2024, yesterday. I was advised that he will not testify today and will likely not be called for several weeks, but that they would try to let me know by next week. Mr. Arnold originally agreed to testify when he entered into his plea deal in December of 2022, now approaching 2 years ago. Mr. Arnold has kept in constant contact with me over the past 2 years to make sure that he would be available whenever the state might call him as a witness. The first time that I was contacted by the state about Mr. Arnold being called as a witness was on August 13, 2024 by Adrian Love. Ms. Love asked if I could not appear with Mr. Arnold if there was anyone who could serve as stand-in counsel for me. I informed Ms. Love that I was not willing to allow any stand-in counsel to stand with Mr. Arnold during his testimony, and I asked Ms. Love to give me some general indication of when Mr. Arnold's testimony would be needed. On September 4, 2024, the state told me Mr. Arnold was needed within the next few days. I immediately emailed Ms. Love and Investigator Long with a few dates for which I had leaves of absence on file for September and asked for the state to provide me with an anticipated time frame for when they might call Mr. Arnold to the stand. I received no response by email, but Ms. Love called my cell phone the evening of September 11, 2024, and also sent a text message asking me to reach out to Investigator Long about the timing of Mr. Arnold's testimony. I responded to the same email chain, providing all the dates we were available and the few dates that I was not available. Ms. Love indicated that she would be calling Mr. Arnold as a witness in September. So I wrote Ms. Love and the court about 5 days for which I was on leave in September. Mr. Arnold was never called as a witness during this time, and no one from the state ever updated me on when Mr. Arnold might be called as a witness until last week. On October 8, 2024, Investigator Long emailed me and copied Mr. Adam Abate and not Ms. Love about Mr. Arnold's testimony. We were told Mr. Arnold would be called as a witness sometime latter, part of the week of October 14, 2024. We were asked to meet so the state could give notice of his impending testimony. I provided a very detailed response advising the state that I could have Mr. Arnold testify beginning October 14, 2024 and anytime through October 18th and beginning again on October 22nd, 2024 through October 25th, 2024. Since Investigator Long had mentioned in his email wanting to provide notice of Mr. Arnold's impending testimony, I drafted my October 9, 2024 letter to Ms. Love and copied all parties, including the court, to clarify that Mr. Arnold was not avoiding service of any subpoena and intended to testify if called as a witness, but that we just needed some accommodations, such as a notice to ensure that I was able to accompany him for his testimony as his attorney. On October 9, 2024, Investigator Long emailed me that they would provide a date for Mr. Arnold's testimony within 48 hours. He also said that they would provide me with anything that the state wanted Mr. Arnold to review prior to his testimony and answer my question about whether the state intended on asking Mr. Arnold any additional questions that would involve his Fifth Amendment privilege and/or grant of immunity. On October 11, 2024, Investigator Long advised that Mr. Arnold would be called as a witness on October 16, 2024. But that they would keep me posted as the trial progressed. He also advised that Mr. Abate would be responding about whether there were any prior statements the state intended to use to refresh Mr. Arnold's memory, and whether the state intended to ask any questions outside the proffer he provided that might implicate immunity or Fifth Amendment concerns in the interest of expediency, and to avoid wasting the jury and the court's time. I previously had asked the state to send me any prior statements the state may wish to use during Mr. Arnold's testimony. On October 14, 2024, I wrote Investigator Long and Mr. Abate to confirm that Mr. Arnold was being called at 9 a.m. on October 16, 2024, and to again ask about those two outstanding questions regarding prior statements and questions outside of his proffer. In response, today, October 15, 2024, Investigator Long responded that Mr. Arnold's testimony would not be needed this week and that the state did not anticipate his testimony taking place in the next few weeks. He wrote further, "I do not have a date certain as of now. Mr. Arnold and I have now been on call since January 2023. While we realize that trials sometimes are unpredictable, we have been available for the past 22 months now. Moving into November 2024, I'm specifically set for jury trial next week of November 18, 2024, and will be on medical leave beginning November 22, 2024. Given how other witnesses have been required to testify with stand-in counsel, Mr. Arnold is very concerned that the state is purposefully delaying calling him to the stand so that he will be denied his right to have counsel of choosing, the same counsel that negotiated and is familiar with the terms of his plea deal. I'm kindly asking the court to instruct the state to advise me whether, in fact, it intends to call Mr. Arnold at all, so that we can avoid any unnecessary waste of the parties and court's time and resources. If the state still intends to call Mr. Arnold as a witness, and to the extent the court can address potentially evidentiary and privilege issues before they arise, and to expedite Mr. Arnold's testimony in the presence of a jury, I believe advising the court of the history with regard to Mr. Arnold's plea negotiations and plea agreement would greatly assist the court in ruling on potential issues, factual and procedural history regarding Mr. Arnold's plea. In 2024, Mr. Arnold was charged in indictment 14 SC 13-1032, to which he pled guilty to a misdemeanor and completed his sentence on February 29, 2016. In 2015, Mr. Arnold was charged in indictment 15 SC 14-0116, to which he pled guilty under the First Offender Act and completed his sentence and was discharged and exonerated on November 1st, 2021. Mr. Arnold was able to complete the foregoing sentences without a felony conviction on his record. Despite this, in 2022, Mr. Arnold was arrested and charged for the same two underlying criminal indictments from 14 SC 13-1032 and 15 SC 14-0116 in the current RICO indictment, and held without bond in Fulton County Jail. Despite having been able to successfully complete probation for both underlying offenses and move forward without a felony on his record, Mr. Arnold was nevertheless denied bond. Having little recourse, Mr. Arnold attempted to negotiate a plea deal in connection with the RICO indictment that allowed him to finally be released from the conditions at the Fulton County Jail. Notably, while the state and Judge Glanville both were unwilling to grant Mr. Arnold a bond, they were willing to let him be released on probation, provided that he provide testimony sought by the state. Mr. Arnold, however, was unwilling to make all of the statements that the state sought, so Mr. Arnold was again sent back to Fulton County Jail to languish without a bond. After further and deliberate negotiation, the state agreed to accept the statements Mr. Arnold could swear to under oath and agreed to release Mr. Arnold on probation once he made those statements and agreed to testify for the state about those statements. Mr. Arnold agreed only to the specific statements set forth in his plea agreement, and he was very clear that he intended to retain his right against self-incrimination under the Fifth Amendment to the United States Constitution should any party seek to question him about any matters outside of the specific statements contained in his plea proffer. On December 16, 2022, Mr. Arnold entered his plea, which allowed him to remain on probation. A copy of the plea colloquy is attached here too. Since the entry of his plea, Mr. Arnold has been in full compliance with the terms of his probation, for which reporting is set to terminate in December of this year. The state has not suggested Mr. Arnold has not complied with the terms of his probation, nor could it. Also, noted above, Mr. Arnold has been ready to testify within the confines of his plea agreement. Recently, the state called one of Mr. Arnold's co-defendants to testify pursuant to his plea agreement. This witness did not receive a grant of immunity for his testimony, and unlike Mr. Arnold, apparently did not retain his Fifth Amendment privilege when he entered into his plea agreement. After this witness testified, the state filed a motion to revoke his probation for what the state believed was a violation of the terms of his probation. The state alleged that the witness directly contradicted the special conditions of his plea agreement by disavowing the factual acknowledgments he had sworn were accurate and true during his plea hearing. The state then argued that this witness had the opportunity at the time he took the plea deal to correct or clarify any statements and the factual acknowledgement before affirming their truth under oath. Mr. Arnold has serious concerns that the state may, without any authority, attempt to do the same thing with Mr. Arnold. For this reason, Mr. Arnold wishes to advise the court in advance of his testimony why such an action by the state would be improper and illegal. As internal matter, when Mr. Arnold attempted to correct or clarify the statements contained in his original factual acknowledgement, he was told if he did not admit to the statements as written, he would be sent back to Fulton County Jail, held without bond, and placed on trial with his co-defendants. Mr. Arnold continually explained that he could not answer to all of the statements that the state wanted him to swear to in the factual acknowledgement. Notably, after Mr. Arnold was willing to return to the Fulton County Jail and stand trial, the state amended the factual acknowledgement to remove those statements for which Mr. Arnold had no knowledge. In other words, the parties specifically negotiated the scope of the factual acknowledgement to significantly narrow the potential scope of Mr. Arnold's testimony, which included a separate constitutional right to remain silent. We are writing to advise the court and the state, outside the presence of the jury, that if the state intends to call Mr. Arnold and ask him questions about facts that are not contained in his plea proffer or questions that are worded differently from the statements in Mr. Arnold's plea proffer and then attempt to use those statements against him as it has with another witness in an effort to revoke his probation, Mr. Arnold will assert his Fifth Amendment right against self-incrimination and will refuse to answer any such questions. Mr. Arnold's assertion of his Fifth Amendment rights, however, which was specifically contemplated by the express terms of his negotiated plea agreement, cannot be used to revoke his probation or to hold him in contempt. In addition, at no time between the date of Mr. Arnold's plea and the present has anyone from the state suggested to me that Mr. Arnold would be offered any immunity for any testimony he may give. Nonetheless, based on the state's history of using immunity to force additional witnesses' testimony in the middle of trial, I outline below several issues for the court's consideration prior to Mr. Arnold's taking stand. Mr. Arnold has no faith in any immunity agreement that the state might put forth in this case, and which has been offered to other witnesses to compel their testimonies under the threat of incarceration without assurances from the court that this immunity will extend to the state's attempt to revoke his probation if they do not like how he answers questions. Furthermore, Mr. Arnold has no faith that the state will not use whatever he says, no matter whether he has an agreement from the district attorney for immunity against him if they do not like how he testifies on the stand. Mr. Arnold's constitutional protections, much like a promise of immunity, ring entirely hollow when the state refuses to honor them, with no guarantee that the state will not try to revoke Mr. Arnold's probation or charge him with another crime based on the same allegations or deny him bail or require him to remain in unconstitutional conditions. The grant of immunity may not be conditional, and therefore the state may not condition a grant of immunity on the testimony of the witness being full, complete, and truthful. To be a valid grant of immunity, the state must make a written request, and the state must make a specific finding that the witness's testimony was necessary to the public interest. Mr. Arnold will only answer the questions specifically negotiated and set forth in his proffer. In other words, he is asking the court to make the state honor its agreement with Mr. Arnold and not allow the state, as it has in the past, to change the terms only after it is unhappy with his testimony. To be perfectly clear, based on express terms of his plea agreement, the state may only question Mr. Arnold to the following. Mr. Arnold is a member of the Rolling 60s Crips. Mr. Arnold became associated or affiliated with YSL in 2015, but not that YSL is anything more than a record label. Mr. Arnold committed the other incident for which he pled guilty to indictment 15 SC 140116, and again in 2022 in this indictment. Mr. Arnold committed the other incident for which he pled guilty to an indictment 14 SC 131032, and again in 2022 in this indictment. Mr. Arnold was present on May 9, 2022 when the search warrant was executed, and he does not claim ownership of any of the items the government claims to have discovered during this search. Mr. Arnold acknowledged that YSL, which he knows as a record label, has the following identifiers. So as a record label, clothing with YSL or slime, pendants with the letters YSL or slat, colors is green for slime, seen YSL members use one or more hand signs, language that members of YSL include slat, which means slime love all the time. Some of the language includes calling each other slime, symbols that YSL uses including green heart and green snake. As explained above, as to any other topics or questions, Mr. Arnold intends to assert his right to remain silent under Fifth Amendment, the Fifth Amendment, which protects Mr. Arnold against any statements that potentially could be used against self-interest. In the RICO indictment, the state has alleged that certain non-criminal acts were overt acts in furtherance of a conspiracy. Therefore, any statement, Mr. Arnold, even as to a non-criminal act, could be used by the state to demonstrate an overt act that could be used potentially to prosecute Mr. Arnold. In that scenario, Mr. Arnold would be forced to remain yet in the Fulton County Jail without bond. Such an action by the state would be an obvious attempt to strong-arm Mr. Arnold into providing additional testimony. Even though the state agreed to the terms of his plea offer, knowing full well to what Mr. Arnold could testify, therefore Mr. Arnold intends to assert his Fifth Amendment privilege against making any such statements that are not covered in the agreed upon proffer, since any statement, as the state argues, can be used against him as an overt act should the state seek to use the information for that purpose. And he is asking this court to uphold the terms of his agreement and to decline any invitation to interpret his failure to testify to facts outside of that agreement as evidence of any probation violation that could be used to rearrest him. It is also my understanding that many of the questions the state may wish to ask Mr. Arnold pertain to social media posts, musical lyrics, and videos and friendships or associations he has. The state has denoted certain of these facts as overt acts and continues to argue that other acts are admissible as overt acts in furtherance of the alleged conspiracy. Therefore, Mr. Arnold intends to assert his Fifth Amendment privilege for any questions about social media posts, musical lyrics, and videos in his friendships or associations, since none of these topics were listed in his plea agreement. She hard, bro. I'm sorry, this woman is the truth. Damn. Despite the foregoing, Mr. Arnold wishes to make certain that he intends to fulfill the requirements of his plea agreement and testify as to the matters outlined in his proffer as summarized above, but only those topics. Mr. Arnold wants to make abundantly clear that based on his fear that the state will seek to revoke his probation should the state seek testimony beyond that in his proffer, he only intends to respond to those specific questions and only if they are worded in the same manner that were posed during Mr. Arnold's plea proffer. If the state intends to inquire into any facts above the scope of his plea proffer, Mr. Arnold is providing the court and the state with notice that he intends to assert his right to remain silent, a right he specifically protected in his plea agreement. I trust this history of negotiations regarding Mr. Arnold's plea and a summary of Mr. Arnold's position in recent issues that have emerged in the context of other witnesses will assist the court in evaluating these issues should they arise during Mr. Arnold's testimony. We happily invite the state to outline its position for Mr. Arnold, the court, and current defendants so that everyone is on the same page before Mr. Arnold's anticipated testimony, so as to ensure his testimony can be taken expeditiously, fairly in accordance with the terms of his negotiated plea, and without violation of Mr. Arnold's Fifth Amendment constitutional rights. Should the court wish to hear from Mr. Arnold on any of these issues in advance of his testimony, I am happy to address them at the court's pleasure. Sincerely, Ashleigh B. Merchant, Nash. I'm kidding. She does. Y'all don't see that part there. I'm just going to be fair, square, obvious, and honest. If Duke comes up there to testify, the state is stupid. Just is. Just flat out stupid. It's not even worth it. We're just going to be fair. It's not worth it. The shit that she is causing, that Ashleigh Merchant is causing before she even steps foot in the courtroom, that she's using with words that she wrote, it's not worth it. The state would be dumb as hell to call him at this point in time because it literally will fuck them up. If any of you people who will say, well, he had identifiers, let me ask you, for the old heads, tell these young cats what this means right here. Yeah, that's The Rock. That's Jay-Z's label. So there you go. You have things like that that identify people as rappers under a certain rap group. You know, the chains like, what's one of my favorite ones? The Terror Squad chain, the TS chain that Fat Joe wore. Do y'all realize right there? There you go. That these labels that have all of these freaking chains and stuff like that to let you know that you are a member of their label, that right here, that's essentially what he acknowledged. So when y'all say this stuff, and y'all know not what you're speaking because we're so raw with emotion to say, no, he's just proving that YSL is a gang. Well, damn, they already proved that in my opinion. People can disagree all they want to. To me, the state has proven that YSL is a gang, but the state has not proven that YSL is a criminal enterprise. Because if we gave it a rating from the Better Business Bureau, they'd have to give a goddamn 0 out of 5. Because as a constructed gang that's supposed to go out and do everything that the boss Slime says, they've all failed. They all need to be fired. And essentially, the shit that they said doesn't make sense. How do you fear somebody, that's what they said, named King Slime, who would have your ass killed if he found out you was snitching, but you've been out on probation for 2 years almost when this year started, because it's 2024. I'm being facetious a little bit with the time. But why ain't nobody killed none of the witnesses? Just gonna be fair, square, obvious, and honest. It just seems as though all of these cats, with the exception of Duke, took bad plea deals. Now, I ain't gonna hold you. Say thou, you might want to get your goddamn client ready because, well, Drew Finland as well. I don't see how y'all don't bring in Gunna and y'all don't bring in YFN Lucci. I just personally don't see it. And they literally, Duke's attorney, Ashleigh Merchant, proved 100% why you shouldn't be taking any kind of deal from the damn state anyways with arresting Moontunk yesterday. So, yeah, because this video dropped tomorrow. So yeah, F all that shit, bruh. We just gotta be fair, square, obvious, and honest. Duke deal doesn't help the state. And if they piss off Ashleigh Merchant, she gonna dig some shit up like she did in this right here. 2016. A security recording system installed in a Cobb County courtroom, tucked away and largely forgotten, provided a glimpse into how the sausage gets made. The camera looks down over the judge's desk and captures workday minutia like clerks at lunch, yakking about lawyers, attorneys, playing paper, rock, scissors, and the judge and prosecutors in idle conversation that reinforces what many already suspect. Judges often see themselves as an arm of the prosecution. In the recording, Superior Judge Reuben Green, a former Cobb County prosecutor himself, seems like a kindly uncle chatting with two assistant district attorneys. Green talks comfortably with them, giving advice on trial strategy and filling them out on other cases. The three talked about a recent case where a guy beat a murder rap after shooting to death his knife-wielding girlfriend. The jury did find him guilty on aggravated assault, and he got 20 years, but he avoided a murder conviction. God, that was crazy, said Green, who couldn't believe the jurors failed to convict based on the cop's testimony, an anomaly in cop. The judge referred to an upcoming armed robbery trial, saying, hopefully this jury does the right thing. Had some unusual cases lately, unusual juries. Cobb has changed demographically and is unsure what he meant by unusual. The judge did not call me back. But generally speaking, judges should hold an actual trial and hear some evidence before declaring the defendant guilty. Still, Green needn't have worried. Cobb is still pretty tough. In the case he wondered about on the tape, an ex-con named Tomdrick Cromer later was convicted of armed robbery and sentenced to life without parole. I know. I can almost hear you guys saying, so what? These guys are scumbags. And you're right. In many of the cases, many of them. But this episode is being used to get Cromer's case overturned. Attorney, check it out. Dun, 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 dun. Ashleigh Merchant stumbled upon the recording and is using it as the basis for her appeal, saying the judge acted like a prosecution colleague, not a referee. I know. So what? These criminal-loving defense attorneys always argue. But there is a problem. Cobb courts must retry an old robbery murder case because the state Supreme Court recently tossed out 2 murder defendant convictions and a third defendant's conviction hangs in the balance. Merchant was an appellate attorney, and that one too. And Green was the judge. The basis for that reversal? The judge's ties to the district attorney's office and his failure to recuse himself. The DA at the time, Green's old boss, Was his campaign treasurer in a previous judgeship race. Green refused to consider recusing himself and even debated the lawyers who brought it up. Sounds familiar? That make judges look hostile and unfair, the Supreme Court noted. You'd figure the good judge might learn to distance himself from his old pals, but it's hard. Prosecutors and judges are often part of the same tribe. Still, judges are supposed to talk to one side about a case without the other. Sounds familiar? Let me reread that for y'all. Still, judges are supposed to talk to one side about a case without the other side present. It's a big deal in the game, which is what the justice system is. It goes to basic foundation of fairness and competing interests, and the judge being an impartial observer. Appearances are reality. Stephen Bright, president of Southern Center for Human Rights and veteran trial lawyers, said this kind of activity goes on every day all over Georgia. The difference here was there was a recording, but this goes beyond the pale, Bright said. It's like the umpire going into the dugout to be the coach. I think he should resign. If he wants to be a prosecutor, then go back to the prosecution's office. Vic Reynolds, Cobb's DA, says people often see judges coming from the prosecution ranks and say, how in the world can they be fair? All they have done is prosecute people. But I have seen a majority of former prosecutors who become prosecutors make a double effort to bend over backwards to be fair, said Reynolds, who was a cop, prosecutor, judge, defense attorney, and now the DA. J. Tom Morgan, a former DeKalb County DA and now a defense attorney, said most judges are pro-prosecution because that's the pool they come from. Prosecutors are groomed on that path. A judge is the next step. In essence, the prosecutory ranks are AA ball for the major leagues of judgedom. Judicial gigs are great jobs. You wear robes during the day and everyone sucks up to you. Morgan added, while Green rules with the prosecution most of the time, I don't think he'd get a defense case. I think he meant he wouldn't get the defense case just for the heck of it. But defense attorneys complain Green often gets cases, and he is widely known as being tough on crime, which is a badge of honor, certainly in Cobb and in most circuits in Georgia. Being fair is good. Being hard-nosed is better when it comes to electability. Heck, Judge Green could even use the videotape in his campaign literature. And that leaves Ashleigh Merchant, the lawyer who started it all. She is becoming known as a legal agitator, which makes changes for the good happen, but it's not necessarily a great career move in the clubby land of criminal justice. I'm a wreck about this, she said. I'm definitely sticking my neck out. I'm worrying about being hurt professionally, and I haven't broken any rules, except the one that says, don't stick your thumb in the eye of a judge where you practice, but it keeps the system on. Ashleigh Merchant ain't to be fucked with. That's why I can call her Ashleigh Merchant Nash. You feel me? Yeah, welcome to the family. But nah, on another note, bro, serious note, what a fucked up thing to do. She got that judge kicked off for a while. He got reinstated, but she definitely got up under his skin. And she said, I'm going to thumb that eye. Injustice. Cool. She going out swinging and she don't give a damn. Now, personally, I'm a lover, not a fighter, so I love to see people who fight. And from what I can tell, she's 100% a fighter. They just need to not even mention Duke ass anymore. If they do, it just goes to show how arrogant all of this truly is as far as the terms, conditions, and plea agreements. Because basically, as Merchant said, I got y'all asses to sign a bad plea deal. Because y'all try to screw us over and make us sign a bad plea deal. So, there's that. But there was one thing that she said where I kind of can agree, but also disagree, and I'll show y'all further proof probably tomorrow with the Moontoon deal, because emotions are still raw. So tomorrow we'll do a video with the Moontoon plea deal and we'll dig a little bit further into it, because there were things that the judge said where she was 100% in the right. And I don't care if y'all say, oh, it's a white woman, oh, you're standing up. No, it's not that. Listen to the words. And I ain't gonna hold you. One of the people that sat in that court flat out told me, man, Paige Whitaker showed me some mercy when she really didn't have to. And y'all know I don't need to make it up. And if you didn't already figure it out, hey, then you done figured it out. But share to keep your people aware. Subscribe to the bell, stay notified. We are 2K away from that $1,000 giveaway. Subscribe today and comment on things, man. Do not just sit there and subscribe and not comment on anything. Shit. All it's looking like right now is it's a raffle of 50 people. That's it. 50 people. I would like my chances. Y'all better increase that shit up to like 1,000. I'd rather get 1,000 names than shake the hell out of a bag and get carpal tunnel and all of that crap, so that way we can find out who won. Other than that, if y'all want to subscribe and just let it go off, then we let it go off. But I will pose a question in the community tab probably tomorrow. No, tonight. And I'm going to ask y'all a simple question. Do y'all think that we should possibly try to hire Ashleigh Merchant from Moot Toot to get out of prison? Now, let me say this right now. I have not talked to anybody in Moot Toot's circle, his family, or nothing like that. I do believe I can get in contact with them, and there's that. But I want to see and I want to know if we can hire Ashleigh Merchant to go ahead and do that, because I could ship off an email to Ashleigh Merchant and see how much she costs, and then literally let y'all know if she's even interested, because it seems like her understanding of what the hell just happened and what was going to happen is better than that whack-ass lawyer that he had. So we'll ask that question later on, because honestly, I still feel bad for Buddy. Even though technically the Honorable Paige Whitaker spared him because he committed perjury, and on top of that, she could have revoked the whole 20-something. You know, Glanville ass would have did it. He was looking at 35 years, 38 years, well, 37 years, if she wanted to be an asshole about it, and she chose not to. But we still want to see that man get out, because we don't think he really did nothing wrong over here, even though technically he did.